Is this working? We'll just wait for a few more people to join in. Is the sound and all fine? We'll just wait for 2 minutes to start the discussion. We'll just wait for a few more people to log in. So just to give a brief introduction while we wait for people to join in, the topic that we will be discussing today is actually both a little controversial as well as a little boring, if I remember from my college days, because whenever the fundamental rights chapter is discussed in college, most of the focus remains with the golden triangle and the other provisions which are there. Very rarely is much time spent on the article we are going to talk about today, that is Article 29 and Article 30, which forms part of the fundamental rights chapter. Because, I mean, however, even though it's not one of the most discussed provisions amongst law students in college, it still remains to be one of the most hotly debated provisions when it comes to interpretation by the Supreme Court and various high courts. During the course of today's discussion, I'll take you through a few of the judgments which have been passed, wherein the push and the pull between the executive and the citizenry when it comes to the interpretation of these two provisions, that is Article 29 and 30, will be seen. So just to give a brief introduction as to what these two provisions which we are dealing with today refers to. So first and foremost, the topic which we are going to discuss today is the rights of minority institutions under the Constitution to admit students of their own choice. Now, before we go into the nitty-gritties of the subject, let's see what the constitutional provisions are. The two relevant constitutional provisions for today's discussion, two directly relevant provisions, are Article 29 and Article 30. Now, these two are under the heading cultural and educational rights. It's important because the heading is not minority rights. Even though the provisions 29 and 30 both refer to the word minority, the heading under which the provisions are kept is cultural and educational rights. Now, there are two types of minorities which are recognized under the Constitution. One are linguistic minorities, that is a minority based on language. The other is religious minorities. Now, this is where the real issue arises in a vibrant democracy like ours, which calls itself a secular country. So even at the time of the Constituent Assembly debates, there was a lot of discussion as to this addition of religious minorities under Article 2930. Because again, coming back to the heading of the two provisions, it's cultural and educational rights. So the view which was there, one of the view was that what needs to be protected is the linguistic right, because a language is a unique thing dissemination of information or education at a lower level or at every level in your local language, in your mother tongue, becomes very important, and therefore that needs protection. Religious minority protection should not be there, especially in a constitution which seeks to be a secular constitution. However, as we all know, both the minorities under the religious as well as linguistic minorities were eventually covered under both the provisions, and then we get to see how it plays out. Now, the other provisions which are important for today's discussion is Article 14 and 15, which obviously talks about equality and equality on the basis of religion, that nobody should be discriminated upon on the basis of religion. The next provision is Article 19(1)(g), which refers to the right to profession and business. Because as we will see how the law develops, 19(1)(g) is a right which has been has been invoked by the various minority colleges over and above Article 30. Now, coming to the two provisions and the salient features which are provided under that, Article 29(1) says that a religious minority, Article 29(1) says that any section of the citizen residing in the territory of India or any part thereof, having a distinct language, script or culture of its own, shall have the right to conserve the same. Now again, importantly, if you see this provision, it does not talk about religion. It only talks about distinct language, script or culture. So 29(1) only seeks to protect these three. 29(2) is very, very important, which says that no citizen, which is again akin to your Article 14 and 15(1), which says no citizen shall be denied admissions into any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, language, or any of them. So what do we get from 29(2)? 29(2) is that nobody can be denied admission into a educational institution run by the state or receiving state fund on the basis of religion. Now here comes the dynamics. The very same heading, two provisions, 29 and 30. Article 30 states all minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. To pause here for a minute, as I stated, minorities here as compared to what we saw in 29 is very specific, that it can be both a religious minority as well as a linguistic minority. And importantly, just as a matter of information, the definition of minority will be on the basis of state, not the country. Because if we go by the country issue, Hindus, which is the majority religion, can never be a minority. However, interestingly, in a few states where the Hindus are actually, or maybe a particular sect of a Hindu is in minority, they can claim to have minority rights under Article 30. Because of this very definition, that what needs to be seen is the state as a unit and not the country as a whole. Just bear this in mind, because when we come to the latter part of the discussion where we talk about educational institutions, it will have a bearing. Now, laying down the foundation, these are the constitutional provisions which we are concerned about. One more provision which is there, which is neither here nor there, is Article 51A, which is the fundamental duties. Clause clause J, which speaks that the country shall strive towards excellence in all spheres of individual and collective activity so that the nation constantly rises to a higher level of endeavor and achievement. So just keep this in mind, because again, as is with the discussion on reservation, whenever there is a carve out, whenever there is a particular specialization which is kept only for a particular group, the argument on the other side is always that excellence is undermined. Now let's understand why are minorities required to be protected. We need to go back to the 1947-48 when the constitution was being prepared by the Constituent Assembly. Right after at 47, 46, 47, 48, at the time of partition, we obviously saw a lot of hardships faced by minorities in our country. There was a constant growing fear that in a country such as ours, where the majority, that is the Hindus, is so overwhelmingly large as compared to the other minorities, that they will lose out on their own identity once they join the Union of India. So to protect those fears and concern, it was important that this provision was included in the fundamental rights chapter. This is not a constitutional right, it's a fundamental right wherein minority institutions were given this protection. Now, another important factor which needs to be seen in Article 30 as compared to Article 19 is that Article 30, at least in the text, is an absolute right. There is no qualification. 19.1 has the qualification of 19.2, 3, 4, 5 and 6. Namely, under particular circumstances, the state can encroach upon the freedoms guaranteed under 19.1. But the right of a minority institution under Article 30, at least from the text, is an absolute right. Having laid this platform, let's see how the Supreme Court over the years have sought to interpret these two provisions in the context of educational institutions and, in my opinion, diluted it to an extent that today actually Article 30 just remains on the Constitution text but has been denuded of its rigor. Whether it's correct or wrong, it's for everyone to decide on their own. But if we actually see how the judicial interpretation has slowly restricted this right, which originally textually was an absolute right, it will at least give an indication that the right has been denuded of its vigor. Now, the first time that this article came for discussion was in the year 1957 when the Kerala Education Bill was introduced. So a reference was made by the President under Article 143 for the opinion of the Supreme Court as to the scope and ambit of an educational institution, the right to establish an educational institution, the clause, the phrase which is found in Article 30. What does that mean? What does the right to establish and right to administer an educational institution of their choice mean under Article 30? So there are two things which the judgment referred to. The citation is 1959 SCR 995. It's a 7-judge bench decision. So what I will do is today, because of this is a really wide discussion which has multiple facets, I will restrict the discussion only to the aspect of the right to choose the students that they want to admit. There are various facets which are involved in administration of an education institution, the kind of teachers you want to have, the kind of staff you want to have, what kind of conditions can be put upon by the university for grant of recognition or grant of affiliation. Those aspects are all there. keep it in mind, but today we will restrict it to the right to choose the students that they will seek to admit. So in Re Kerala Education Bill, the Supreme Court held that when we mean that the right to administer under Article 30 naturally cannot mean the right to maladminister. So therefore, what do we get? The first message that we get is that this is, even though it's an absolute power, it's not an unbridled power. So if, say, a minority institution wants to do mass scale corruption, where they only admit students who are willing to pay the management quota fees, that cannot be permitted. So administration cannot go to the extent of being maladministration. So that was the first, so to say, caveat put to this absolute right in the year 1959. Thereafter, there are two judgments which obviously do not deal with the right to admission, but it deals with affiliation, conditions put by the university at the time of grant of affiliation. These are the St. Xavier's case, which is 1974. It's a celebrated judgment because it's a 9-judge bench judgment. And the St. Stephen's College case, which is again a 5-judge bench, which is 1992. In both these judgments, it was recognized that Article 30 is a special right which is given to minorities. The right to administer naturally includes within it the right to choose students of their own choice, because this of their own choice, this phraseology is very, very important, because this choice, even though is not unbridled as held by in Re Kerala Education Bill and so on and so forth, it has been the consistent case of the minority institutions that if we have a system which is different from the regular system of admission, so long as we are not going below the threshold which the regular system is fixing, we should be permitted to have our own system. Now, just to give you a small flavor as to what this may mean. So, I had the privilege of doing the Christian Medical College matter before the Supreme Court. So, Christian Medical College is a very, very unique institution which is over 100-year existence and is one of the top class medical colleges in the country. They have a special so the college was set up with certain values which are Christian values which come down from the teachings of Christ. So at the time of admission, one of the requirements which the college also puts is that those beliefs which the college on the basis of which the college was set up should also be inculcated into the students. So therefore the students are also tested at the time of admission for an aptitude test, whether they have it in them to have that spirit of actually curing an individual, not being overtly swayed by a monetary consideration, but actually wanting to do well for the society, and so on and so forth. There are many other institutions. There is the Mahatma Gandhi Medical College in Pune, if I'm not wrong, where the college is built on the principles of Mahatma Gandhi. So therefore, at the time of admission, an aptitude test is held to see whether the incoming student actually follows certain Gandhian principles which that college wants to protect. So there are these aspects which are there. So these are additional criteria which a college may want to put, which is over and above the regular criteria. So this does not undermine the basic criteria for admission of students, but is definitely not the mainstream criteria. So now this is where the dispute started arising, and we started having an issue between the state for framing guidelines and these institutions. So the first time we actually saw a shift from the autonomy given to these colleges was in the Unni Krishnan judgment in 1993. The citation is 1993 1 SCC 645. So this was a constitution bench, 5-judge bench decision. This was dealing with professional colleges. Now, another thing which we need to bear in mind is professional colleges also became a much more business oriented, lucrative arena by the time the 90s came in with the liberalization and everything. So, even as a society, professional courses were becoming much more valuable as compared to the earlier years when the arts and the regular courses were of prime value. So, the Supreme Court took note of widespread anomalies in the admission system of these professional colleges and held that the state should actually frame certain guidelines to administer the process of admission and the fees of professional colleges. So this is where for the first time the fee regulation in professional colleges started. Naturally, the regular professional colleges had an argument under 19(1)(g), but that was limited. But the minorities institutions had a higher argument so far as Article 30. But the court said, again, going back to those key words in Re Kerala Education Bill, that administration cannot amount to maladministration. So therefore, anything which is necessary for upholding the standard of education, we must do. And therefore, both the admission process as well as the fee structure was sought to be curtailed by this judgment. Now, this created widespread issues. There were protests, there were legal challenges, there were various kind of debate amongst both at a political level as well as at a legal level, because Unni Krishnan, to a great extent, even though just as a matter of information which may be there, Unni Krishnan was actually the origins of Article 21A, that is right to educate, right to primary education as a fundamental right. So Unni Krishnan was a very well-intentioned judgment, because at that stage the court was of the view that colleges should not become a business, a profit-making business. Colleges should remain a noble profession, and therefore it should be available and accessible by all without any problem. But anyways, there was a huge issue insofar as the minority institutions are concerned. The challenges mounted, and ultimately 11-judge bench was formed, which is the famous TMA Pai judgment. So 11 judges sat, they framed certain questions to be answered. The important question for our purpose was that to what extent should the state have a right to regulate the admission process of the minority institution. And unequivocally on this point, the 11 judges held that Unni Krishnan seeks to dilute the right under Article 30, and obviously the principles of maladministration has to be kept, but the test is that so far as the process which is being undertaken by the minority institution is just, fair and reasonable and transparent, the minority institution should be permitted. So what they said is what I was basically stating earlier, because this is basically the rule which we have all come to learn since our college days, that this TMA Pi is the ground rule which has to be followed, that a minority institution must maintain the basic threshold. If they want to keep a standard which is higher than that threshold, they should be permitted, but it should not go below the threshold. So that's the test which ultimately TMA Pi holds. And it also holds, which is very important, and which again goes back to what I originally said, that keeps on diluting what does Article 30 mean. It said that it is of course true that government regulations cannot destroy the minority character of the institution or make the right to establish and administer a mere illusion. You can't put regulation after regulation to control how a college is to be run, and still say that you have Article 30, which gives you a right to administer of your own choice. So this is very important. This is 11 judges, TMA Pi. Now, as we have often seen, that just passing of a judgment by a big bench does not solve problems for the citizen. On the contrary, at most cases, it creates more confusion because of the different concurring views and what is the ratio and what actually the court wanted to say. And this is exactly what happened with TMA Pi. Even though it was a 11 judge bench, I emphasize the word 11 because this is the second highest size of bench which the Supreme Court has had in its 70 years. The only bigger bench is the Keshwananda Bharati 13 judge bench. So just consider that thing in mind to see the enormity of the situation. That you required 11 judges in 2002 to actually clarify something which the text is very simple. But now comes the irony. Just 1 year later, we had a constitution bench of 5 judges in Islamic Academy of Education of the state of Karnataka, interpreting TMA Pi to clarify whether there can be government quotas in minority institutions, even though they are self-financed. So the reason of this self-finance is important because this takes you out of the scope of Article 29(2), which said that if there is an institution which has state aid, there can be no discrimination on the basis of religion and so on and so forth. So these were all unaided institutions. So there was a question that arose that I am unaided, I am outside the rigor of 29(2). TMA Pi says that I am allowed to administer my institution of my own choice. So therefore, this fee structure should go, the fee fixation regulation should go, and the admission process regulation should go. I should be allowed to do everything, and you check it on a case-to-case basis. Here, the court again went back to Unnikrishnan because, we like it or not, there are two aspects. One is the reality of life, where we know how institutions function, and the other is the purity of the constitutional text. The reality is that there is a problem with the fee fixation by these colleges. So therefore, in Islamic Academy, the Supreme Court went back and created a kind of a balance between Unnikrishnan and TMA Pi and stated that even though minority rights are protected under 30, they have a right to choose their students, but so far as the machinery of admission is concerned, the state can form a machinery. The minorities are free to evolve their own machineries also, satisfying the test of fairness and transparency which was laid down in TMA Pi. But there can still be regulations of this admission process. Now this again created a problem because you had the UGC Act, the Medical Council Act, the AICTE Act. So we slowly started having these regulatory bodies for all the professional courses. AICTE, Medical Council of India, UGC. So they all had the regulations. So this again, the minority institutions were up in their arms saying that again our rights are being curtailed. This led to the final word on TMA Pi, namely PA Inamdar versus State of Maharashtra. This is 2005 6 SCC 537. This is a 7-judge bench. Thankfully, this was a unanimous judgment, and funnily so, in PA Inamdar, the judgment starts with the Chief Justice Lahoti, if I'm not wrong, actually making a comment that we need to interpret this one article in the Constitution. We've had 5 judges in Unnikrishnan say something, 11 judges correcting and clarifying it, only for 5 judges to confuse the issue 1 year later. So with this introduction, this judgment starts, and they ultimately reconcile all the judgments which have been passed and formulate the test which I have probably mentioned 2-3 times: fair, transparent and non-exploitative. So that is the principle which follows for any minority institution for their admission process. Now this is where it stood for some time till 2010, when the NEET examinations were introduced by the government. So, I mean, as I said, the ground reality is that there are huge issues with medical colleges, and a centralized, transparent system is always good. As for us lawyers, the CLAT happened in 2007. So similarly, the MCI introduced the NEET examination in 2010. Naturally, the provision obviously required that all admissions in medical colleges will be only through NEET, and no other college can have their own admission process. This was obviously to control the huge problem which was there with absolutely fraudulent and non-existent private medical colleges, and that's a problem which is like a epidemic so far as our country is concerned. So with the introduction of NEET, there was again a fresh challenge which was brought about. In 2013, in the case of Christian Medical College, the Supreme Court, 3 judges struck down NEET and said that it impinges upon the minority institutions' right as well as the other colleges' rights under 19(1)(g), and it's an unfair restriction. Thereafter, NEET was, and there was also an aspect of it was done by way of a regulation and not by a statutory amendment. So there was the whole issue of a delegated legislation going beyond the statute. This was corrected thereafter, and we had a constitution bench judgment in the year 2016 called the Modern Dental College versus State of Madhya Pradesh. This dealt with state level common entrance test in the state of Madhya Pradesh, Maharashtra and a few other states. So for whoever is aware, there are these state centralized examinations like the Comet K in Karnataka and in Madhya Pradesh. So the Supreme Court again interpreted that fair, transparent and non-exploitative clause of PN and held that it's all good, but again administration cannot amount to maladministration, and therefore having a centralized examination by itself does not dilute Article 30 rights, and thereby upheld the concept of centralized education entrance test. Now this was a massive fillip to this NEET challenge. The 2013 judgment which I mentioned was reviewed and reopened, and this year in April 2020, the Supreme Court reviewed its earlier judgment and upheld NEET, as we are all aware because NEET is happening all around us, upheld the concept of NEET, followed Modern Dental, diluted PA Namdar and TMA Pi, and said merely having a centralized examination system does not dilute the right to admission or right to admit students of their own choice for minority institutions. Now so that takes care of the entire judicial process starting from 1967 Kerala Education Bill, where there was just a small step or a caveat put to the Article 30 right, that is administration does not or should not amount to maladministration, to today where the entire admission system, at least insofar as medical colleges are concerned, has been completely usurped, and the minority institutions have to adhere to the NEET, which is a centralized examination formulated by the central government, to admit students. There is obviously one additional aspect, which is the counseling, common counseling which takes place. That is under challenge, so therefore I will not go into it much, but there is a slight semblance of the right of Article 30 left, if at all, for the minority institutions. So now, to just summarize what we have discussed so far, Article 30 started off by being an absolute right wherein the minority institutions could have the right to choose their students, right to set up the management the way they want to without any interference from the state. This was important because, again, historically it was believed that minority must be protected and they should be given an opportunity to preserve their culture and their ethos. Over the years, obviously, as we have moved more and more towards progressive society where all these have started to matter lesser and the importance of the education system has become higher, the need to actually provide an equal playing field for all concerned. Because one more thing, most of these minority institutions are also top class institutions, where admission is very difficult. I mean, I remember in 2004-5 when we were when we were in the process of taking admission, most of my friends who were trying to opt for medical colleges stated that CMC has probably on a national basis only 12 seats for 100 seat batch. So it was that competitive for the non-minorities and for the for the general quota, so to say, to take admission in these kind of high level colleges. So in keeping that in mind and in the overall scheme of things, from a societal point of view, maybe it is important and correct that Article 30 right needs to be diluted. We've always said that if the constitution is a living constitution, it must evolve with time. We can't be stuck in the 1948 for the rest of our lives. We have seen Article 21 being expanded each time to bring in new rights. So, in the fundamental right chapter, in my opinion, this is the only right which has been constricted from time to time, and to the extent that today it may appear that it only remains on the textbook with very little actual right which is available with the minority institution. So that's the thing. If there are any questions, I'll be happy to answer. Otherwise, I think we can close the. Okay, thank you guys. It was a pleasure.